So a comprehensive estate plan is going to provide documents that put your wishes on paper with regard to managing your assets and your healthcare during your lifetime if you're incapacitated, and distribution of your assets after you die. So for the lifetime documents, we're thinking primarily a healthcare advance directive and a durable power of attorney. And for distribution of your assets, that can really either be a will, a standalone will that goes through probate court to administer your estate, or it can include a trust, or lots of trusts if you want to do some complicated planning, but a trust is a separate way to manage your assets, in which case your trust would hold assets and be distributed according to the terms of the trust after you die. So one of the things that is helpful is to work with an attorney to answer those questions along the way.
When I think of estate planning in general, you're looking at one of the goals is try to direct how your estate would be distributed upon your passing. And there are two real main tools that we use for that within our world, which is a will or a trust. A will would direct the disposition of your estate where you own assets solely in your name at the time of your passing, and there's no beneficiary. So there's no joint owner, there's no beneficiary associated with that asset, and title is solely in your name. That's going to go through a process known as probate, and the will is going to govern who administers that asset. They're known as the executor, and how those assets would be distributed, who the beneficiaries are. A trust we use in some circumstances to avoid that process, but in many cases it's a will substitute, and we avoid probate in that process by titling assets in the name of the trust during your lifetime, or directing them there through beneficiary designations, so that upon your passing the assets are subject to the terms of the trust and are distributed according to its terms. So when we're looking at how we are going to dispose of, or direct the disposition of a client's estate, we're primarily looking at one of those two options, a will or a trust.
Everybody should have an estate plan.
You've got to be 18 usually.
True. So kids
or
cannot.
married, but most of the time these days, fortunately, people are not married when they're under 18.
Right. So once you're an adult, you can start thinking about having an estate plan.
But we often do see clients come at various stages of life. I think it's pretty common. We have some clients who are like early in their adult lives and are going away to college or going out on their own and want to name usually a parent as an agent. Yeah, I usually tell clients like every 5 to 10 years or whenever there's a major life event, a marriage, a divorce, a birth, a death. Those are good times to check in and make sure that the documents read the way you want them to.
Some people will put off estate planning because there's some difficult questions to answer in there. The minor children is a big one. Who's going to be the guardian of our minor kids? Your brother, my sister, and we just can't decide. And so people will not write a plan because they can't answer those questions. And we like to say, don't let trying to create a perfect plan get in the way of having a plan.
I think when you're getting prepared to meet with your estate planning attorney, it's important to sit down and think about what your goals are. And then also thinking about who are the people that you trust in your life to make financial decisions in a way that would support what your goals are, and to make medical decisions for you if you're unable to. And also the big question, who would take care of your children if you have minor kids? Those are all things that it's helpful to think through before you meet with your lawyer. An excellent estate planning attorney is going to talk to you about your goals and help you think through those. And some of them you might have answers to, some you might have questions about. When I meet with a client, one of the things I like doing is going through each of their assets and figuring out where things stand now. How would your assets that you own pass to other people? We kind of put each asset into the different box, and from there we can decide, or my clients can decide, what next steps they want to take to ensure that their goals are met. Anytime we don't plan, there are defaults under the law as to what will happen to us, whether we're incapacitated or when we die. Those defaults might work for you, and it might be what you want. It might make it easier to plan, but certainly putting your wishes on paper makes it clear what you want to have happen, both with your body and also your stuff.
People sometimes ask, can I do a DIY estate plan, right? We do everything DIY these days. We, file our own taxes. People don't hire financial advisors sometimes. It's not usually a good idea in the estate planning arena. There are some software products out there, and perhaps they'll continue to get better over time. But unfortunately, we've seen a lot of people make mistakes, not intentionally, but using those products because they don't necessarily know the right questions to ask. And we've had a lot of, post-death conflict and fights where wills were done with an online process, and the cost of administering and dealing with them in that situation exceeds many times what the cost would have been to just do it right the first time.
A living will here in New Hampshire, it's part of your advance directive. So it's guidance to your agents under power of attorney for healthcare about life support or life-sustaining treatment, what type of medical treatment you would want to receive while you're still living. And it's guidance to those folks that you appoint as your agents and your doctors about how to treat you if you're unable to make your own medical decisions at that point. Whereas your will, a last will and testament, if you will, does not come into play until you have died. So one's a living document, literally living with you, and your last will and testament kicks in after you die, and your living will dies with you.
Probate is a process to move title from the name of the person who is now deceased to those who are beneficiaries under a will or heirs of the estate in the absence of a will. So it's a process that we have to go through when we find ourselves in that situation. It's a court process, and so a lot of people get scared about that because they want to avoid court, and there are reasons to do that. But it's a process that can be simplified for some and can become complicated for others. And so I think if you're concerned about probate, you should talk to an attorney about what that might look like in your case, and if it's desirable to try to avoid it.
Revocable trust, just like the name implies, can be modified, can be changed. And so for most people setting up an estate plan that includes a trust, we're going to have a revocable trust as part of the basis of that plan. Then they want to still be able to control the assets, right? Because they're your assets, so you're not ready to give them away yet. An irrevocable trust is more like what you think of when you think about a trust that's been set up for somebody, like a trust fund.
Right.
And they're used for various reasons, sometimes tax planning, sometimes planning for a beneficiary, where you want to put money aside for them now, but you're not ready to have them have that money outright. You want to have it managed by a trustee. And a revocable trust will always become irrevocable when the individual who creates it, which can be an individual or a couple creating it, dies. Because once you're no longer able to revoke it, now it's irrevocable. So typically in New Hampshire, executors, if they are taking a fee, will take a reasonable hourly rate times the hours performed. So I always tell clients, if they're becoming executors, even if they don't expect they're going to take a fee, that it's a good idea to keep careful track of their time. And that way, if they get to the conclusion of the process and for whatever reason it makes sense for them to pay themselves a fee, then we would have the records to support that fee.
I would just add that the executor's fee is income. And so if the executor does end up taking a fee for the work that they do, it is a job, it is work, certainly. You do get to be paid for that, but that is considered income to you. So the executor needs to be aware that they need to report that as income on their individual tax return as work that they did in the year they were probating the estate. Why it's important to talk to an attorney, help you walk you through that probate process, pros and cons of taking that executor fee, how to track your time, how to log your time, how to share that with the beneficiaries within accounting. So we are here to help if and when you need it. Here in New Hampshire, the creditor claim period is 6 months. That means that if somebody passes away and they pass away with valid debts, last hospital bill, credit card debt, personal loan, things like that, that they owed somebody money when they passed away. When their estate is opened, their executor is appointed. Creditors have 6 months from the date of that appointment to let the executor know, hey, the decedent owed me money, here's my claim. There's an order and priority in which the executor will pay them back. So costs of administration come first, you have funeral expenses, taxes, if there's Medicaid payback, and then general creditors, things like those credit cards and things like that. So they have to work through that order of priority, but as long as there's sufficient money or assets in the estate to pay those valid debts, that gets usually handled within that 6-month window. But anytime past that, the executor has to continue to administer the estate.